What's up, YouTube? How y'all doing, man? Check this out. Sometimes I like to the podcast with Soul. My man, shout out to him, man. God, y'all go check his channel out and everything. He was saying that he liked to report on both sides of the fence. So I like to hear what he have to say. Well-spoken brother that actually gives me insight on how they think Diddy is winning. I can't see how anybody can think the man is winning in any situation after what he done did to Cassie, you know. So that's just my opinion. Everybody got one, you feel me? So y'all hit that subscribe button, hit that bell. Hey, let's check this bad boy. Here we go.
All right, y'all, what's up? Good morning.
Good morning.
So today is Monday, June the 16th, 2025. I'm on my way into Manhattan to the court to cover the Diddy trial. Make sure you follow me on Instagram at the Podcast with Soul. Make sure you follow me on Spotify at the Podcast with Soul. I want to thank everybody for following me on Spotify and Instagram. I appreciate y'all, and shout out to all my new subscribers that have come over here. So last night late, I got an email that Alexandra Shapiro, which is Puffy's attorney, one of Puffy's attorneys, has filed a motion with the court for a third mistrial if juror number 6 is removed from the jury. So the letter is dated June 15, 2025. Dear Judge Submaranian, the defense submits this letter in further support of its vigorous opposition to striking juror number 6, a black man. Then it's redacted. Mr. Combs would be substantially prejudiced by the dismissal of this juror, and because there is no factual basis to remove him under Fazio, the court lacks the discretion to do so. Moreover, if the supposed inconsistencies in his answers to the court's questions were truly of concern, then it's redacted. If the court strikes juror number 6, we respectfully request that a mistrial be declared. We understand that the court has refused to find any discriminatory motive in the government's actions with respect to its peremptory strikes or this motion. Now, peremptory strikes are when they're doing the voir dire process, and this is going to come up later in this letter. A peremptory challenge is when they're doing the voir dire, right? The voir dire is the process where they bring down 100, 200 jurors and they narrow it down to 18 and they ask them all a bunch of questions. Are you biased against the government? Are you biased against Puffy? Have you ever had a family member in prison or had any interaction with the police? Have you ever been to prison? You know, they try to find through the voir dire process the most impartial jurors that they can find, right? Now, a peremptory challenge is a defendant or lawyer's objection to a proposed juror made without needing to give a reason. Attorneys use their peremptory challenges to exclude jurors based on the crudest racial stereotypes. So when they interview these jurors, you know, the prosecution can say, well, we don't want this juror for, you know, they are biased against hip-hop artists, or the defense may say we don't want this particular juror because they work for the post office, which is a government organization, and they may be biased inside with the government, right? And you have to give a reason. But both sides, the defense and the prosecution, I think were given 9 peremptory strikes, meaning you could strike a juror without giving any reason. If you don't use your peremptory strikes, you have to give a reason why you're striking a juror. In Puffy's case, the federal government, the prosecution, used 7 of its 9 peremptory challenges against potential black jurors. If the court strikes juror number 6, we respectfully request that a mistrial be declared. We understand that the court has refused to find any discriminatory motive in the government's actions with respect to its peremptory strikes or this motion. However, we respectfully and regrettably disagree. The government's motion must be evaluated in light of the entire history of this investigation and prosecution, and not in isolation. Unfortunately, when considered against that background, it is impossible to believe that this motion is merely a good faith attempt to raise a valid question about the juror's integrity, rather than an effort to take advantage of an opportunity to strike yet another black male from the jury. A, there is no valid basis to dismiss the juror. To begin with, as the court noted during the morning session on Friday, it does not have discretion to remove a juror where there's a bias in the removal of the juror or where there would be prejudice to the defendant, with prejudice meaning that the discharge is without factual support or for a legally irrelevant reason. They give a case, United States versus Fazio. Here, there would be significant bias and prejudice to the defendant, and there is no factual support for dismissing the juror. First, there is no question Mr. Combs would be severely prejudiced if the juror in question were removed and replaced by the first alternate. We have previously pointed out that this juror is one of only 2 black men on the jury, but it should also be noted that he is the juror who is perhaps most similar to Mr. Combs in other important ways. He is a black man, and then it's redacted at the top. Moreover, the case involves serious charges of sexual misconduct against women who were in relationships with Mr. Combs. As the opening statements and the witness testimony have revealed, the principal dispute between the parties is whether Cassie Ventura and Jane Doe willingly participated in the sexual activity at issue during their relationships with Mr. Combs for their own reasons and because they chose to do so, or whether, as the government claims, they were coerced. The fairness of the trial depends in part on having jurors with backgrounds similar to Mr. Combs share their perspectives on the evidence with other jurors from diverse backgrounds during deliberations. Removing this particular juror will deprive Mr. Combs of that important perspective, and it is no answer to simply say that there are other black jurors or other males on the jury. Second, there is no factual support for the government's position or, respectfully, the court's statements Friday afternoon, which were in stark conflict with the court's apparent recognition Friday morning that the purported inconsistencies were likely completely benign. As we explained at length in our letter of June the 12th on this topic, there were no material inconsistencies with respect to any juror said during voir dire and in the June 9th colloquies. And the juror's willingness to perform this public service and his civic duty should be considered a positive rather than a negative factor. There is no evidence whatsoever that he had an agenda or a bias in favor of either party, and no legitimate reason to jump to that conclusion.
Oh, okay.
Indeed, the court had an opportunity to assess the juror's demeanor, not only during voir dire, but also at a closer proximity in the robing room during 2 colloquies on June 9th. The court never suggested at any time or at any time before Friday afternoon that it had any reason to doubt that the juror was doing his best to be forthright and honest with the court. During Friday morning session, after having reviewed both parties' submissions, including the government's lengthy quotes from the relevant transcripts, the court indicated it was inclined to agree that there was an insufficient basis to find that the juror was being deceitful and intentionally so, as the government charged. Now, these are the words of Judge Submaranian. And so the defense's submission is really that the answers, given the nature of the inquiry both in jury selection and during the current process, was vague enough so that the answers could easily be reconciled with each other. And the subject matter of what was being addressed is so far afield from the juror's performance of duties that that's not a reason to remove the juror. The real suggestion from the government as to the reason why the juror should be removed is because if you take the inference against the juror's credibility, there is a view that if you can't reconcile the answers and the juror was being deceitful and intentionally so, either in jury selection or in the colloquy in the robing room, then that would be grounds to disqualify the juror. For that to happen, we would need to have a further inquiry with the juror because on the current record, there is an insufficient basis to make that determination, meaning there's an insufficient basis to remove the juror. And in terms of how we view the inquiry post-jury selection, I think that there's a difference. I think that when we address these types of questions during the jury selection process, there may be an inkling or a suggestion that there's a reason to disqualify a juror for cause. And that has one standard, but it's before the exercise of peremptory challenges and impaneling of the juror. And so that has one standard. I think the defense's suggestion, and I think it's consistent with a lot of the cases, is that the default actually flips once you have the jury actually in the box and you have a regular jury and alternates. At that point, you need something more to disqualify a juror. And the cases cited by both sides have situations presented that are far more extreme than what has been presented. Moreover, the court indicated a preference for further inquiry. It specifically noted, quote unquote, this is Judge Submaranian, I think that it is likely that what we will hear will be a perfectly innocent explanation for the answers. I don't think that they are irreconcilable. I think that for the reasons that the defense has stated, there's a way to reconcile the entire record. The court also noted that the only reason why this situation even came up is because of a statement that was made on the juror's own volition to jury department staff in a friendly and in an offhand banter. Alexandra Shapiro quotes more of what the judge said on Friday. The court further observed, and there's perhaps an understandable way to reconcile all of these issues, which is that I believe that the question that was initially asked during voir dire, during the group proceeding, was where do you live? And then kind of who do you live with? But based on the answers that were being given by the group, it could have been that the juror thought, where do I live? I live in the Bronx. And that would be consistent with everything that we've heard, because he indicated that he had moved out of the Bronx in the last 2 weeks. And there might be some ambiguity about how much time he was spending in each place. But that's at least what he said. As to the second question, he might have understood it to be, who is your family group? Who is in your family group? As to that question, he indicated his fiance and his baby daughter. And so you can reconcile these things. And given what we're talking about, which is where do you live, and kind of basic questions, it would be surprising that someone would try to make up something about it. Maybe even if there was some consistency, it wouldn't rise to the level of removal of a juror. And that's what he said early in that morning on Friday, given the various constitutional and other rights that the defendant enjoys. The defense expressed concerns about any further inquiry because of the likely negative and intimidating impact it could have on the juror, especially after the government started suggesting a line of inquiry that could lead to a concern that the juror's employment was somehow in jeopardy. That's what they were saying. the government, the prosecution on Friday was saying that the judge should reach out to juror number 6's employer, to find out the truth or whatever. Where does he live? And Alexandra Shapiro jumped up Friday and says, listen, you can't be reaching out to the man's job. You know what I'm saying? Now you're harassing the man. It's bad enough you've harassed him twice since we've been here. And right here it states that if they start reaching out to his job, then he may feel threatened, like, I could lose my job. I got a baby daughter. Let me side with the government when it comes to deliberation and a verdict. In response to the court's comments, the government ultimately stated the most prudent thing to do is to ensure the integrity of the proceedings would be to have an additional inquiry. It endorsed further fact-finding, stating that such fact-finding was necessary to ensure the integrity of the proceedings. The court said it would consider the parties' arguments and whether to conduct further inquiry later. Now, I highlighted this part. Check this part out. In light of the discussion in the morning, the defense was stunned when the court announced at the end of the day, in stark contrast to its extensive earlier remarks about why there was an understandable way to reconcile the jurors' answers, that it believed the juror was either unable to follow simple instructions and answer simple questions, or was shading the truth or being deceptive, and would dismiss the juror without further inquiry. Respectfully, there is simply no evidence to support the court's very serious accusation or its stated concern about the juror's ability to fairly and impartially apply the rules of law of the court to the facts of this case, to consider the evidence in a fair way, and to follow the instructions of the court. The court later stated that when the juror said he had a New York license and still maintained his residence in the Bronx, this was somehow nefarious and suggested an effort to try to get onto the jury. But the juror was already on the jury and had sat through over 4 weeks of trial, having been willing to serve, which many citizens aren't, and having dutifully devoted all this time to attending the trial. Why would the juror not want to complete his service? Why would he not emphasize that he is still a legal resident of New York, even if he spends several nights a week, I guess, at his girlfriend's house because it's redacted? There is not a shred of evidence that he had a pre-existing agenda when responding to voir dire questions, as opposed to a willingness to do his civic duty. And the statements the court cited were made after weeks of service, not at the outset. Should the court exclude juror number 6 on the current record, it will no doubt have a chilling effect on minority jurors' willingness to serve in the future, a step in the wrong direction. The government has previously argued that racial disparities in jury service exists because Black and Hispanic people disproportionately fail to respond to jury qualification questionnaires. But juror number 6 answered the call and is dutifully performing what the court stated was a tremendously important task, recognized by the Constitution itself. We should invite his service as well as the service of other potential jurors in his community, not discourage it. Third, if the bar is that low, then to avoid any bias, the government's motion continues a pattern of overreach, suggesting a discriminatory motive in challenging juror number 6. Although the court denied their Bastin challenge and said it found no basis to suggest the government had a discriminatory motive when it sought to strike juror number 6, We believe that motive is supported not only by its remarkable decision to use 7 of its 9 peremptory strikes on black jurors, but also by the history of the investigation and prosecution, which has been characterized by extreme government overreach from the beginning. Peremptory challenges during jury selection. The court accepted the government's proffered reasons for its peremptory strikes of black jurors as race neutral. Nonetheless, it is important to note that for many of these jurors, the purported reasons themselves were based on the jurors or their relatives' interactions with law enforcement, including prior convictions. But it is well documented that there is a long history of systemic discrimination that has led to mass incarceration of black and Hispanic people in this country, and of discrimination in how law enforcement treats them in comparison to white people. Moreover, a 2022 study of 3,200 innocent defendants exonerated in the U.S. since 1989 revealed that black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. Citing a prospective juror's former conviction or their relative's former conviction or facts that they have had a negative interaction with the police only reinforces the race discrimination that led to the over-investigation and over-prosecution of blacks and other minorities in this country. People should not be precluded from serving on juries because of a prior conviction or a relative's prior conviction, or the fact that they had a bad experience when the police stopped their car on a pretext or conducted a stop and frisk on a pretext. Indeed, if they had a negative experience with the justice system, that is a perspective that is important and useful for a diverse jury. For these reasons, in recent years, courts like the Washington state courts have implemented rules for closing the use of peremptory because a juror has had prior contact with law enforcement officers or has a close relationship with people who have been stopped, arrested, or convicted of a crime. Here, the government justified several of its strikes on this sort of basis. For instance, the prosecution said one reason for the first strike was that the juror had a fiance that served 4 years in prison for a drug conviction. A reason supplied for the second strike was that he had been arrested 3 times, including for harassing a police officer. The fourth strike was a juror whose ex-husband had spent 21 years in prison for attempted murder, and she remained close with him, and had a brother who had been incarcerated for 2 years based on a drug conviction. The government justified its fifth strike in part on the basis that the juror had 2 brothers who each did time in prison for felony convictions. Another strike cited inconsistent explanations of interactions with police. History of investigation and prosecution. For starters, it is notable that Mr. Combs, one of the most successful and self-made black men in America, and a person who was an icon not just in the black community, but in the music industry, the fashion industry, and otherwise, was indicted by the Southern District of New York's Civil Rights Unit. When the unit was established, former U.S. Attorney Damian Williams was quoted as saying, "White supremacist groups are on the march, anti-Semitism is on the march, anti-Asian violence is on the march, abuse of the most vulnerable in our society is on the march. But this prosecution has nothing to do with civil rights enforcement. What is being prosecuted is allegations about private sexual activity Mr. Combs engaged in with two of his former girlfriends and third parties." All of this was part of a coordinated effort to try to destroy one of the most successful black men in American history. All of Mr. Combs' ventures are entirely legitimate, and the government has never suggested otherwise. Instead, the government's case is all about his personal life and what he and his romantic partners have done in the privacy of the bedroom. As the trial has shown, the most significant evidence against Mr. Combs involves domestic violence incidents normally dealt with by local authorities or family courts. Yet the prosecutors have made a federal civil rights case out of how Mr. Combs and his former girlfriends conducted their private sex lives. The theory of prosecution not only has nothing to do with civil rights enforcement, but it is also unprecedented. Indeed, we are unaware of any federal criminal case charging racketeering or sex trafficking based on allegations that a man and his past long-term adult girlfriend sometimes brought in a third party, a male escort or entertainer, into their sexual relationship. Since its inception, the case has been rife with overreach and unusually aggressive tactics normally reserved for prosecutions of violent gangs, organized crime, and terrorism. The purported victim never complained to law enforcement. Ms. Ventura's lawsuit was settled for $20 million, and she never made any complaint to the Southern District of New York or any other law enforcement agency, nor did Jane Doe. Indeed, the government labeled her as a victim and bail arguments long before it had even interviewed her. And she claims to have testified only because she was compelled to by subpoena. The government has devoted enormous resources to this case. The undersigned are not aware of any other recent case involving more than 5 assistant U.S. attorneys. And here we have 6 at trial, along with 2 filter team assistant U.S. attorneys and multiple actively involved supervisors. What Ms. Shapiro is saying is there are 6 prosecutors on this case, which is like unprecedented. And they got 2 other people on a filter team and supervisors. Additionally, the Department of Homeland Security assigned multiple agents to the case, and numerous other agents have assisted at various points, including hundreds of heavily armed agents in combat gear who executed military-style raids complete with armored vehicles on Mr. Combs' Los Angeles and Miami homes in March of 2024. And the government also apparently retained a highly paid jury consultant in this case, which is exceedingly rare for the government to do. A consultant who may well be advising the prosecutors in connection with the instant motion. Another bullet point. The Southern District of New York refused to engage with defense counsel during the investigation. Mr. Combs' lawyers approached prosecutors as soon as they learned of the investigation, even before the warrants were executed, and requested an opportunity to meet. Yet the Southern District of New York refused then and repeatedly refused thereafter to engage with counsel substantively through the investigation and leading up to Mr. Combs' arrest in September 2024. The prosecutors also refused to allow Mr. Combs to voluntarily surrender.
Okay.
Presumably to create another media spectacle like the one orchestrated during the raids below. Check this part out. The Southern District of New York used misrepresentation and material omissions in warrant applications. Although the court denied our Frank's motion, the defense has documented how the Southern District of New York obtained the March 2024 warrants to search Mr. Combs' homes, person, and all his electronic devices using materially misleading applications. They omitted extensive evidence undercutting the credibility of Ms. Ventura and other witnesses the warrants applications relied on to establish probable cause. For instance, when obtaining the warrants, the government completely disregarded extensive evidence then in its possession showing Mr. Combs and Ms. Ventura's relationship was, though at times toxic, consensual and loving. The applications also relied on several other witnesses the prosecutors later admitted were not credible. These witnesses were part of a feeding frenzy of grifters who were trying to extract money from Mr. Combs after the Ventura lawsuit became public. Yet the prosecutors failed to disclose the financial motives of these witnesses and concealed exculpatory evidence that the government had in its possession when it sought the warrants. Investigators used excessive force and created a media circus during the raids of Combs's homes. The search warrants were executed in a manner calculated to garner press attention, sensationalize the case, falsely portray Mr. Combs as dangerous, and taint any future jury pool. Agents leaked the government's plans to the press in advance to maximize media coverage and put on a show. The agents used excessive force against Mr. Combs' children, who were in his home doing nothing wrong. One agent held a semi-automatic rifle to the head of Christian Combs, even though he was visibly complying with the agent's demands. Another had a semi-automatic rifle with a laser sight trained and the orange dot visible on the middle of the chest of Justin Combs, who was also complying with the agent's instructions. The agents then handcuffed them and paraded them in front of the news cameras and a TV helicopter invited by the DHS, who were waiting to get salacious footage of the staged perp walk of two innocent young men. Number 3, investigators leaked a steady drumbeat of false and prejudicial information to the press until the court issued a broad gag order opposed by the government. Throughout most of 2024, DHS agents repeatedly leaked information about the investigation to the media, including extensive amounts of highly prejudicial false information about minors, sex dungeons, cameras in the bedrooms, and a host of other prejudicial information that has caused online conspiracy theories to multiply. As the court is aware, the prosecutors repeatedly denied that these leaks emanated from its case team by describing that the team is in an artificially limited way, and even opposed the request for a gag order that would prohibit all Department of Homeland Security agents, not just the limited few Southern District of New York claimed were on the case team, from leaking sensitive information about the case. While this litigation was ongoing, the leaks continued unabated. It was only after the court issued the broad gag order the defense sought that the leaks finally ceased, long after the jury pool had been deeply tainted. Since then, the government has repeatedly invoked the gag order and Local Rule 23.1 to prevent the defense, which has a right to try to combat the unfair tsunami of nonstop negative coverage from any media engagement. At the same time, the government has failed to oppose in any way the numerous apparent violations of that rule by alleged victims and their counsel. Prosecutors insisted on detaining Combs even though he did not present a risk or flight of danger. The prosecutors insisted on detaining Mr. Combs even though he offered to surrender, traveled to New York once he learned he would be charged, and obviously was not a flight risk. They also misled the courts that held the initial detention hearings. For instance, they told the district court the CNN video refuted Mr. Combs' account of the Intercontinental event, that the incident occurred after the couple had an argument over Mr. Combs' relationship and that involved the phone. They said that was just not what happened and just another cover-up, just more lies, even though nothing in the trial evidence contradicts the claim that the fight occurred because of jealousy in the relationship. They cited a third victim, Gina, who the prosecutors have entirely dropped from the case. Prosecutors surveilled Combs in jail and invaded the defense camp. The prosecutors next took advantage of Mr. Combs' incarceration to spy on him and invade the defense camp. violating his attorney-client privilege and his First Amendment rights. As the court is aware, shortly after Mr. Combs was detained, the Bureau of Prisons investigator began monitoring his communications, including calls with attorneys and sharing information with prosecutors. During an allegedly unrelated October 24 general sweep of MDC Brooklyn for contraband and evidence of corruption, agents completed their search of certain parts of that facility and asked the Southern District of New York whether or not they should continue their efforts and search Mr. Combs' unit. A Southern District of New York supervisor told them to search Mr. Combs' unit.
Guess he started getting hot.
Because the government's interest in Mr. Combs specifically and law enforcement agents proceeded to do so. During the ensuing search, the investigator who had been working with the prosecutors confirmed there was no contraband among Mr. Combs' personal effects, but nonetheless rifled through his possessions and photographed Mr. Combs' notes, reflecting conversations with his attorneys and ideas for defense strategy. The investigator then told a member of the case team about the notes and turned them over to the Southern District of New York, which tried to use them to oppose a renewed bail application, claiming they showed Mr. Combs was trying to obstruct justice. The court granted a defense application to order the prosecutors on the case team to destroy their copies of the privileged notes. Another bullet point. The prosecution continued their spying and next argued that Mr. Combs' other writings and communications from MDC supposedly involved obstruction, even though these materials were clearly protected by the First and the Sixth Amendments. Some reflected his participation in defense efforts to obtain material that could be used to challenge the credibility of the government's witnesses. Other writings described Mr. Combs' view that the prosecution is racist and his desire to get that message out to counter all the negative media about the case. The Southern District of New York even went so far as to claim Mr. Combs' request that his children post a happy birthday message to him on Instagram was an effort to obstruct justice. Because Mr. Combs hoped it would present him in a more positive light to the public and undo some of the taint to the jury pool caused by all the negative publicity ginned up by the government and civil plaintiffs' attorneys. Prosecutors abused the filter team to access privileged information. The government's invasion of the attorney-client privilege and the defense camp has not been limited to its seizure of Mr. Combs' notes. Throughout the case, the Southern District of New York has misused the purported filter team, which was supposed to ensure that the prosecutors handling the case were not exposed to privileged materials on the numerous electronic devices and internet accounts the government has seized and searched. Following execution of the March 2024 warrants, defense counsel provided the prosecutors with the names of attorneys who had represented Combs and his businesses so that potentially privileged materials could be segregated from the case prosecutors. Our understanding was that a filter team would not provide any potentially privileged materials to the case prosecutors without first affording defense counsel the opportunity to review the materials, so that counsel could assert privilege if necessary, and so that any privilege disputes could be resolved by the court in camera. Instead, the filter team has repeatedly passed along potentially privileged information without first seeking our input, requiring us to claw back privileged communications after the case team had already been tainted by exposure to the materials. I think this is the last page, y'all. Prosecutors used the grand jury to help unscrupulous plaintiffs obtain publicity for wild false claims. After Mr. Combs' arrest, while continuing its investigation, the government publicly paraded witnesses into the grand jury to feed nonsensical media narratives that they knew were false. This created an atmosphere of legitimacy surrounding the many false and wild claims about Mr. Combs and the media circus created by unscrupulous plaintiffs, lawyers who have encouraged people to file bogus lawsuits against Mr. Combs. Next one. Prosecutors attempted to introduce unreliable, decades-old, highly inflammatory allegations and used allegations about additional victims who never testified to obtain search warrants and seek detention. The government attempted to prop up its case with old, unreliable, and highly prejudicial and inflammatory Rule 404B evidence, much of which the court correctly and unfortunately excluded in granting the defense's motion in Lamine. And although the court denied the motion to exclude the testimony of one alleged victim, another girlfriend who had no interaction with any of Mr. Combs's employees or the alleged RICO enterprise, that individual apparently has decided not to testify. That's Gina. Likewise, the government spent over a year claiming that Mr. Combs's former girlfriend, Gina, was a victim and used that allegation to support arguments for bail and to obtain warrants, and presumably in the grand jury, even though. And the government did not call Gina as a witness. Despite including her in the indictment, the government has not elicited any evidence at trial that could possibly support the conclusion that she is a victim. Prosecutors have engaged in other misconduct during trial. We recognize that the court has denied over 2 mistrial motions, but as the court is aware, we believe the government asked inflammatory and highly prejudicial questions of Inspector Jimenez to try to suggest Mr. Combs had somehow orchestrated the destruction of fingerprint evidence in 2012, and then presented testimony from Cassie Ventura and Brianna Bongalin that it knew or should have known was materially false. The government's history of these extremely aggressive tactics in this case is critical context against which its attempt to remove juror number 6 must be evaluated. In this case, the prosecutors have repeatedly flouted their office's proclaimed tradition of doing the right thing the right way for the right reasons. Their pretextual motion to dismiss juror number 6 is just one more attempt to gain an unfair advantage at the expense of Mr. Combs's right to a fair trial, which is all we ask this court to preserve. For the foregoing reasons, this court should allow juror number 6 to remain on the jury. If the court truly believes his statements raise serious concerns about his ability to follow instructions, which we respectfully submit would be unfair and unsupported conclusion based on what were at worst imprecise answers to the court's questions. If the court dismisses juror number 6, the unfair prejudice from replacing him with the first alternate at this late stage of the proceedings warrants a mistrial. That's it. All right, y'all, I'm finna go into the court.
That's bull.
I'll see y'all at noon when I come out and do my live. That's it. So we're gonna go find out now what they're gonna do with juror number 6. Peace.
So you mean to tell me if you have to replace a juror in any court case, that's a mistrial, right? Have there ever been times where they replace a jury and it wasn't a mistrial? Boom. So we can keep rolling, basically. This happens over and over again in all kinds of cases. We can keep rolling. So that's out of the window. Now, suppose this is what I was thinking. Y'all, I say I'm gonna hold this to the end. Suppose they trying to keep jury number 6. This black man, they trying to keep him. And this jury number 6 already got his mind made up. I'm putting Diddy in jail. Imagine Uncle Mike being jury number 6, right? We already know how I voted. Put him under the jail. In fact, he don't even need to come upstairs while we sort this mess out. We just need to know how much time the boy gonna get. If they put R. Kelly in jail, I couldn't think of his name, y'all think? I couldn't think of his name. R. Kelly. Okay. But yeah, man, I think that Diddy should he should serve some type of time, because there's so much proof that he was reflecting on the dark times of his life. I always try to use his words. Sometimes you got to do that. He admitted that he was beating on this girl. That was one time. So take half of the times that the other 5 times that she said and everybody else saying that he did it over and over again, but she stayed. I understand that, but then the rugs, they don't say the D, they say the rugs. Then on top of that, now your kids, man, you got to go to jail, dog. I'm sorry. And it's funny how, if y'all think about this, man, it is funny how these laws are almost made to protect the bad guy. I want you to think about that. I'm gonna get on up out of here. Y'all take it light, take it slow. Tell them Uncle Mike told you so. Peace out.